is now in session. The Honorable Rachel Pickering presiding.
Thank you. You may be seated. Good afternoon. My name is Judge Rachel Pickering, and I will be your presiding judge for the Wichita afternoon docket. I want to do a quick introduction. On my right is the Honorable Amy Klein, and joining us today is Honorable Carrie Hipp. Judge Hipp graduated from Fort Hays University and Oklahoma City University School of Law. She began her career at Sedgwick County District Attorney's Office right here in Wichita. Judge Hipp later moved to Ellsworth, where she worked in prosecution, criminal defense, domestic, and government law before she became a district court judge in 2019. So this afternoon's arguments will consist of just two arguments. Parties can state their appearance when they individually come to the podium. So with that, calling two cases today. We call State of Kansas versus Kenny Thomas, case number 127433.
May it please the court, David Miller appearing on behalf of the appellant, Kenny Thomas. And I would request of the court 5 minutes, to reserve 5 minutes for a vote.
5 minutes is granted.
Thank you. This case, this appeal arises from a case where Mr. Thomas was, we submit, acting lawfully in self-defense. We submit he should have been granted immunity from prosecution because a motion for immunity was litigated pre-trial. But then at a minimum, once it went to trial, he should have been allowed an instruction on his actual defense at trial. And that is, was his use of deadly force reasonable? In conjunction with that, had the jury been properly instructed on the use of deadly force, the presumption that his use of deadly force, if he was using such in his place of work, that presumption would have applied. The jury would have started out with the presumption that his use of deadly force was reasonable. And then, of course, that's a rebuttable presumption for sure. But as the Macomber court set forth, and we've cited it in the brief, that presumption carries significant weight with the jury. I'll start with the immunity motion. And one of the issues in the district court was whether this was Mr. Thomas's place of work. Place of work is not defined in the statute. As far as I can tell, there's not any case law that interprets what a place of work is. I went to the dictionary definition for lack of any authority, and it's pretty broadly defined as a locality that has boundaries. And then work is defined as the performance of any task or duty, fairly broadly defined. There is a dissenting opinion from Bellinger in the state of Kansas. I understand dissenting opinions carry no weight, but at least there was recognized in the dissenting opinion that a ranch could potentially be a place of work. We cited a Pennsylvania case, again, not controlling on this court, where the Pennsylvania court found that the defendant working in his strawberry fields was in his place of work. So I think certainly if there's an issue or if there's a question about, if there's an ambiguity about how to define place of work, this is a criminal statute, and I think the rule of strict construction or the rule of lenity would require any doubt or ambiguity should be interpreted in favor of Mr. Thomas, that this was his place.
Again, the rule of lenity only applies if there's some doubt as to the statute's meaning.
That is correct.
And we could look at, there's some analogies in Kansas to find, I mean, there's other areas of the law that talk about place of work, like in work comp, we've got kind of the coming and going rule, so we're looking at place of work, and that's been interpreted to be more like your place of employment or your job, correct?
That's true, and
So why shouldn't we interpret this statute, the use of place of work in this statute to be place of employment? Like your workplace, your job?
well, first of all, when we're talking, this is a criminal statute when we're talking about the use of deadly force and self-defense, which I think kind of sets this statute apart from perhaps a workman's compensation statute. But even aside from that, the evidence that was presented below was that Mr. Thomas was doing in some form work. He was repairing the buildings. Some of the places were used as warehousing at the parking lot. Some of the buildings were used as warehousing. And he was actually working. He had employees there that were actually working to get the Treatco factory back up and running again. So again, whatever definition that we give place of work, when you talk about work, he said there was never a time since 2011, I think there was testimony, there was never a time since 2011 that he was not working there in some form or another. And so.
But it wasn't like a place of employment like you would think of as your job, correct?
No.
And I ask that because there isn't any legislative history to speak of, particularly with the addition of place of work, which was kind of a late addition to the statute. But when you look at the creation of this presumption and what it's protecting, we have your home and your car and your place of work. And those, if we think of place of work as maybe your job, those three things seem like places where maybe your guard might be down, where you're not thinking about protecting yourself. You have kind of a sense of comfort. You feel safer in your home, in your car, at your job than you might out and about in public. And so why shouldn't we interpret the statute kind of looking at all the things that are protected with the presumption to help us define what place of work should be and how we should interpret it?
Well, I think Mr. Thomas was entitled to feel safe and secure on his fenced-in property. And when we're talking about, Kansas, and this is a Kansas statute, we are largely an agrarian state where we have farmers, we have ranchers. I think probably it would come to surprise to farmers and ranchers if they were to say that, if they're out farming their land, if they're out working in the garden, outside their home, that somehow that is not their place of work.
Well, if they're a farmer or rancher, that's their job, right?
Correct.
So then they're working on their ranch.
Correct.
I mean, here, I wonder if, the analogy might be like if you have some rental property and you're fixing up a rental property, it's not your job, but maybe it's a business, it produces some income. It seems like that's maybe more what Mr. Thomas was doing, is kind of fixing up this property, correct, to hopefully someday make it into something or back to something. But it wasn't a going concern, and it wasn't his source of income, correct?
As far as, getting rent from the property, probably not. But again, there were business enterprises going on there in the sense that he charged for renting out some of the buildings, warehouses, and so forth. So there was some business enterprise that was going on. We think sufficient, especially given the lack of a definite definition under the statute, that this should be interpreted to be his place of work. The presumption below, as we have argued, we do not believe was rebutted. And I know Judge Magana found, well, even if this was his place of work, that this was rebutted. And I wanted to focus in on, and I'm citing from volume 10 of the transcript and page 27. And certainly this is towards the end of his ruling, but Judge Magani says, and the defendant's belief that one of the alleged victims had a knife because his hand was in a pocket or going into a pocket from 20 or 30 feet away is not sufficient under the facts, in my opinion, to support a reasonable belief under the totality of the circumstances. And that's why there was evidence 2 days before this that Mr. Thomas was confronted by another trespasser who had a throw knife. And Mr. Thomas said, stop. The person continued to approach and actually had a throw knife, which Mr. Thomas said can be thrown with accuracy between 30 and 40 feet. Not only that, that incident occurred generally in the exact same location where the two trespassers in this case approached Mr. Thomas. And so certainly as we've argued, that prior incident of March 31st would have been relevant not only to his state of mind, but also to the objective prong as well. That is, a defendant under the particular circumstances, would the use of deadly force have been reasonable?
Is it reasonable, though, when it's somebody completely different 2 days before? I mean, that's thrown out. What if he had pulled out a gun? Or what if he had pulled out a machine gun 2 days before? Does that mean that that same kind of bad act is attributed to these two new people? I mean, I'm concerned you're allowed to loop that in. I'm not sure I follow the logic.
Well,
It would explain his fear.
yes.
It would explain his fear.
Yes.
But would it be reasonable to think he's pulling for a knife?
Given Mr. Thomas's testimony is that the two trespassers on that night were approaching him. He said halt, and I understand there's some discrepancy there, but he said halt, they didn't. He said he saw them reaching towards their midsection. Again, in the exact same location that was just 2 days before. I see my time is out.
Like this morning, and welcome back.
Thank you.
We want the panel to be able to ask questions, and are there any further questions?
I do.
So we're going to continue a little
yeah.
bit longer.
Okay.
Well, I have a question on a new issue. I'm not a fan of asking about a new issue in rebuttal, and then the other side doesn't get an opportunity to respond to it. And so I want to talk about a different issue that you haven't touched on, and that's the jury question.
Okay.
And the question that I kind of want to hone in on is, it's my understanding is you're asking for some statements that weren't admitted into evidence and claiming that those statements should have been given to the jury when they asked for them. Is that correct?
That's correct.
Do you have any legal authority that would allow a district court to provide a jury with evidence that wasn't admitted at trial to the jury in response to a question?
Well, and I argued the rule of completeness. And so the transcript, there were two transcripts that were used of the immunity hearing by the prosecutor in cross-examining Mr. Thomas.
But again, that's an evidentiary rule, right? That we're dealing with in trial normally and not after evidence is closed?
Yes, but the transcript was not just simply being used to refresh his recollection. They were actually reading verbatim, question, answer, again, using it to defeat or undermine Mr. Thomas's claim of self-defense.
And what stopped defense counsel from asking for that statement to be admitted at the time it was used, or by redirect, asking him questions about the things that were talked about?
And I completely understand what the court is saying. And I did ask for this matter to be remanded. I did file a Van Cleve motion and that's one of the issues that I raised is ineffective assistance of counsel, specifically with regard to that issue, but also with regard to not asking for instructions that are directly relevant to your theory of defense. That is the use of deadly force and then the presumption. In addition to not objecting to what I think is a blatant comment on Mr. Thomas's state of mind and his credibility. So I did ask to be for that to be remanded for a hearing on ineffective assistance of counsel, and that motion was denied. I don't know if it's appropriate in an oral argument to ask that the court reconsider that or not, but if it is, I certainly would ask that the reconsideration of the Van Cleve hearing, because I do think a lot of these issues center on counsel's effectiveness. But nevertheless, under the rule of completeness, we cited the case law, again, not in Kansas, it's out-of-state case law that says if you're basically introducing, through questioning, part of a transcript, as was done in this case, effectively under the rule of completeness, the entire transcript is considered to be submitted into evidence. And so the argument that I made is that when the jury asked specifically to hear Mr. Thomas's testimony from the immunity hearing, or the rest of his testimony from the immunity hearing, that under the rule of completeness, that was in fact evidence that could have been read back to the jury, just like any other readback. Again, I don't have any Kansas case law to say that, but I did cite some out-of-state cases for that proposition. And I think, again, I don't know if you want me to go on, but.
Why don't you wrap it up with this
Sure.
last thought, and then we'll
Sure.
let opposing counsel argue.
Thank you. We would ask, Your Honors, for all the reasons we set forth in the brief, that a reversal, at least on the immunity issue, a reversal back to the district court, because the evidence that was admitted at the immunity hearing was much different from that admitted at trial, and therefore a harmless error under the Phillips standard of harmless error is inappropriate, and that we'd ask that it be remanded back for another hearing on the immunity motion. Alternatively, we would ask for the convictions to be reversed because the jury was not instructed on the correct theory in this case, which is use of deadly force and then the presumption. The jury never had the opportunity to hear his actual theory of defense or consider it. And so we would ask for all those reasons that Mr. Thomas's conviction be reversed for a new trial.
Thank you. You'll have your time on rebuttal.
May it please the court, Assistant District Attorney Matt Maloney for the state. I'll begin, of course, with the immunity issue. And I think the place of work is the starting point for this. And I would pick up on a lot of the questions that this panel asked and with the arguments that I made in the brief. But I think it's important that we focus on what this property actually was. There's no question that at some point in time in the past that this had been an operational business, that there was this dog treat company called Treatco that was used to manufacture these dog treats. But that had burned down, I think about a decade before this incident. The property, as you can see from the video, the Axon footage and the record and some of the pictures, this was a dilapidated property that was in such a state of disrepair that the police officers testified that they had basically been told by their supervisors, unless there's a life-threatening emergency, don't even go onto this property. I think one of the officers referred to it as Chernobyl-esque. You can see that. Not only the buildings themselves were in complete disrepair, but the exterior, the footing, the grass, everything was so overgrown that at one point the defendant told one of the officers to watch his steps so that he didn't fall as they were walking to the spot where he said that the shooting occurred. So this was it was an abandoned property. Now, whether the defendant chose to spend some time there on a weekly basis trying to clean things up, that's really not the question here. And I would note that while that was much the theory of his testimony at the immunity hearing and at trial, on the night of the incident, he told the officers that he really didn't know what his plans were for the land. So the fact that he potentially might have been trying to get this property back into a condition that in the future he might be able to turn it back into an operational business, that's really, I think, a red herring. We're looking at what the state of the property was on the night of the shooting. And as your honors pointed out, no indication that he was making a living on this location, that this was his place of employment. And that contrasts to the examples that council has given today of a ranch or a strawberry field. I believe it was Judge Klein pointed out. Presumably when you're talking about things like that, those are people who are actually making a living on a working farm or ranch or a field. They're actually deriving income specifically from doing that. I would say this would be more akin to if my neighborhood association allowed me to start, I don't know, I planted a garden on the common area and they just let me do it. But I'm not making any money from that. I'm just choosing to do it of my own free will, wanting to grow some things there. That doesn't make it my place of employment. It's a choice that he made to theoretically try to get this place back into some sort of a condition where it would be anything other than an abandoned property. And I think the very nature of this case shows us what this property is. It was so dilapidated, and it was apparently, I think to anybody from the outside looking in, it was abandoned. That's why it became such an attractive location for apparently some of these teenagers and young people to come onto the property. And I would suspect, and I think the record would support this, the reason that those teenagers did that is because there was no indication, there was no signs that this was actually a property that was still in use. So again, the mere fact that he chose to go there on his free time and try to clean things up for the potential of down the road getting it back into operational shape, that's not the question. If he had successfully done those things and Treatco had risen from the ashes one day and he had started running a business again there, then absolutely, that's a totally different question, but that's not our facts. So I think that Judge Magana was correct in finding that this was not a place of work as used in that statute. I would alternatively argue, as I did in the brief, that his alternative finding that the state had rebutted the presumption, even to the extent that it would have applied. I think there's ample evidence of that. The court did consider those previous incidents. If you look at the court's ruling, it's not like the court failed to acknowledge his testimony or that he had said that he had had these prior encounters. The court took everything into consideration, and the court expressly acknowledged that there was conflicting testimony between the defendant and the two victims. And I think it's also important to note that the court specifically emphasized that defendant's own words on the night of the incident, both before the shooting, when he had the police there to haul off this first trespasser, and then his comments and demeanor after the shooting, all of those things were very much inconsistent with what his later testimony was, that he feared for his safety. When you watch that Axon footage from the officers that night, it very much supports their testimony, which was that the defendant was, I think one officer used the word jovial was his demeanor that night, that he was laughing, that he was joking, that
But didn't the defendant try to explain that away? I think at one of the hearings he said, well, my affect was like that because I have ADD or ADHD and I kind of make random comments and I'm trying to explain, like it may have seemed that way, but here's why I was doing it, because I'm uncomfortable and I just say things based on these conditions.
Yeah, I
did the
think
judge take, was that at trial or do you remember, was that at the hearing?
I remember what you're referring to, Your Honor. I don't recall either whether it was trial. It might have been at trial, maybe as a way to try to explain it to the jury. But I think he essentially said, yeah, I was nervous, and that's kind of how I behave. That's fine. That testimony is there. I would argue that that's an attempt on his part to reweigh the evidence now that we're on appeal. The mere fact that he said it didn't obligate the district court to believe it when he was able to view the footage himself. And I think not only the demeanor, but the actual language that he used, of course, the infamous language about how he was going to be sending two to the hospital with buckshot. He called his shot. He said exactly what he was going to do, and he did it. And when you look at what he was telling the officers that night, I think it's clear that rather than fearing for his safety, he was just annoyed. He was annoyed that kids continued to come onto this property. He was concerned about potential vandalism, and he was also, he said he was worried that footage of it would be put on the internet. That was seeming to be his big concern, was he didn't want there to be videos out there that would encourage additional people and additional trespassers to come on the property. He never once told any of those officers, either before or after, that he feared for his safety. It was very much a matter of him being annoyed. And I'm not here to say that he didn't have a right to be annoyed, that trespassers would come on to the property. But that's a separate question than whether he was acting in lawful self-defense when he shot these two unarmed victims from a pretty significant distance. And again, this is where it's certainly relevant that Judge Magana acknowledged the discrepancies in the testimony between the defendant and the victims. And he found that the victim's testimony allowed the state to meet our burden of showing that this was not acting in self-defense. Counsel today emphasized that the defendant said that he thought that there was somebody going for a pocket, that he thought it could have been a knife. He also testified that he had given them a verbal warning and that they disregarded that and kept approaching. Well, the victims said their testimony was absolutely to the contrary, that they never approached him, that they had barely gotten inside this exterior fence or whatever was at the very edge of the property line, that he never said a word to them before he opened fire, and that as soon as they did hear the shots, they both turned and ran away. So the district court was in the position to see and hear all of that conflicting evidence and simply found that the weight of the evidence supported a finding that we had met our burden. And I think there's ample evidence in the record to support that. Turning, I guess, to the first instructional issue, which is about the presumption, I would note that, first of all, I would incorporate the arguments on the first issue as far as why this was would not have been appropriate as an instruction, because it was not a place of work. But alternatively, I would note that the only case that the defense really relies on in this issue of the brief is the McComber case, where the Supreme Court declined to reverse, even though the defendant in that case had requested it at trial and had a more favorable standard of review. So again, when you look at the evidence in this case and the testimony of the victims and all of the other evidence in this case, I would urge this court not to reweigh the evidence in the manner that the defendant is requesting. The jury question issue, I would agree with the points that were made during counsel's argument. First off, I would note that when the jury asked this question, the defense attorney said that he was fine with the proposed answer that the court gave, which was basically, you've already received all the evidence and just referring them back to that. And I think that the reason counsel was okay with that is because it's absolutely the right answer. As your honors pointed out, the transcript from those prior proceedings had not been admitted into evidence. And while, yes, the prosecutor did certainly did examine the defendant using a lot of the questions from that, that's not the same as the full testimony from that hearing having been admitted.
I'm gonna stop you for a second, and then we're gonna rewind a few things and go back with some fundamentals to help me out. The stand your ground hearing is what happened beforehand, correct?
Yes.
And his motion to have that as his defense was denied, correct?
Correct.
And now, the transcripts that were used, was that from that hearing?
Yes, I believe it was the transcript from that, yes.
Okay, so when you have that hearing, you're trying to present that defense to the jury trial, right?
Sure, that would be the
Right.
plan.
So would it be highly prejudicial to the state and contrary to the stand your ground immunity hearing and the judge's ruling if they were allowed to bring in testimony from that hearing in such a manner? Because you're bringing in your defense that the judge already ruled that you can't bring in.
Well, I think the difference would be there that there
So
is...
help me out. Why is
Sure.
that?
I think there is a distinction, our Supreme Court has said, there's a distinction between immunity and self-defense.
Sure, we know
So
that.
immunity obviously being that whether the state can even meet that burden to overcome and put this person on trial.
Right.
But even when we meet that, it doesn't foreclose the defense from putting on a self-defense defense
Right.
at trial. And so I think, I believe that the defense certainly would have been able at this trial if they had chosen to, at the evidentiary phase, just like the prosecutor cross-examined the defendant with these prior statements. I certainly think that defense counsel could have done that in his direct examination or on redirect to try and rehabilitate or to try to point the things that he thought favored his client as opposed to the testimony that the state had used. And so I think to the extent that he's trying to use the rule of completeness, I argued in the brief, that is a rule of evidence. It has nothing to do with how you're to respond to a jury question or with what type of material you're to send back to the jury. And I found it especially telling when I was briefing that issue that even when you look back under the old version of the statute, which was much more explicit in saying that the district court shall read back testimony when the jury requests, even under that statute, our Supreme Court gave district courts some discretion in how they did it. It wasn't simply a carte blanche. If the jury asked for it, you have to give it to them verbatim. But now the statute has been significantly amended to just expressly say that it's in the district court's discretion. And I would agree with Judge Klein. I struggle to think of a single rule of evidence or rule of procedure that would allow a district court to give to the jury something to deliberate that was not put in evidence. And that transcript of the prior hearing was absolutely not put in evidence. And I know counsel's argument is that, well, essentially it was because the prosecutor asked a lot of questions about it. But that's simply not the same thing as having the full testimony from the prior hearing. And even in cases at trial where a jury asked for a readback from trial testimony, you don't see the judge giving them a written copy of the testimony. And a lot of times you don't even see a full readback. The judge will ask them to narrow down their request and say, hey, I'm not going to have the court reporter read back 60 pages of this witness's testimony. If you have something specific, if there's a portion of it you want, tell me and we'll try to work that out. So here we're having him try to put in something that wasn't evidence. It was from a prior proceeding. And again, he could have done so himself. And that leads into my argument, because it's related. I would urge this court not to abandon all rules of appellate practice and allow the defendant to raise this as a 1507 ineffective assistance of counsel claim. I recognize that there are certain very limited situations where IAC claims can be raised for the first time on direct appeal. But this is a situation where these are just garden variety ineffective assistance claims. Counsel should have done this. He should have objected to that testimony. He should have tried to put this evidence in. We're not talking about something like a guilt-based defense or some of the very narrow situations where our appellate courts have said they're willing to consider ineffective assistance of counsel claims on appeal. Of course, there's a possibility that if the defendant loses on this appeal, that he will turn around and file a 1507. But he should have to do that. We shouldn't just skip all of those steps. We have to follow the rules here. And this is very much something that is just a typical ineffective assistance of counsel claim. And so for that reason, I would ask this court not to address the merits of any of the IAC claims that he's raised in his brief. I see I'm out of time. If there are no further questions, our position is that the district court did not err, and we would ask that the defendant's conviction be affirmed.
All right, thank you.
Thank you.
I wanted to address the argument, and the thought just occurred to me The legislature used the term place of work. It didn't use the term place of employment. We are we're supposed to interpret a statute according to the words that the legislature used. I would submit that work is a much broader concept than simply employment, which seems to be the focus of the state's argument, is that, well, this wasn't his employment, this wasn't where he was making money. Work is a much broader term than employment. So I would submit, given the facts below, that this would qualify for his place of work. There was an argument about, Judge Magana ruled against the immunity motion because there was no evidence that the victims were armed. And in fact, that is contrary to Kansas law, as we've argued in our brief. The law of self-defense recognizes reasonable mistakes. Whether someone is actually armed is frankly irrelevant to the issue of self-defense. It's, did the defendant reasonably believe that that person was armed? And I would say that the facts eminently support that, not only from his testimony that as they approached, they were reaching towards their midsection in the pitch black of night, where he couldn't see what they were doing, but also I think relevant is that March 31st incident that had occurred just 2 days before, where there was a person who was approaching him in that area with a throw knife. So I think that absolutely shows a reasonableness on the part of Mr. Thomas. Also, there was some conflict in the testimony, certainly, but what was agreed to by both Mr. Thomas and at least one of the victims, if not both, is the distance that they were from him, about 20 feet. And again, in Mr. Thomas's mind, throw knife that he had just encountered the day or two before is deadly within 20 to 30 feet. So there was agreement, at least on the distance between the trespassers and Mr. Thomas. As far as the question about the transcript, we're not suggesting that the transcript itself should have been just given to the jury for them to read, but certainly they were asking for Mr. Thomas's, the statements that he had testified to in those hearings. And certainly, again, under my argument that, in fact, because significant parts of that transcript were introduced by the prosecutor in a question and answer format, that the entirety of that, at least of his testimony, which is what they asked for, not the ruling of the court or anything else, but specifically his testimony.
So are you saying the jury wanted just what was read, what the prosecutor used to impeach him, to reread that? Or are you now saying they wanted all of it, all the testimony from the hearing?
All they asked for was his statements.
So that would have been what the prosecutor impeached him with?
What the prosecutor impeached him with, again.
So if that's all the jury's asking for is, hey, what did the prosecutor read in cross-examination, then how does the rule of completeness come in to get in these other statements that weren't read by the prosecutor?
Because the prosecutor did not read the entire testimony and context of Mr. Thomas, which is what the jury...
But if the jury didn't ask for the other statements, then how do we get those in?
Well, it wasn't clarified, because they said, the question was, we want Mr. Thomas's statements what was referenced yesterday, I think is what the question was. And what was referenced yesterday was the day before, when the prosecutor went through and was questioning him, reading from the transcript. Again, the question was not clarified by the court, but given that they wanted the complete statement or the full statement of Mr. Thomas, that's where we submit that at least that should have been, that part of his testimony should have been read to the jury, because it had been, in essence, admitted by the way the prosecutor used the transcripts of trial. I see my time is up. I'm certainly willing to answer any other questions the court has.
No,
Okay.
thank you very much.
We would ask that the court reverse Mr. Thomas's convictions.
Thank you. We will take the matter under advisement. This time, we will call the last case of the afternoon docket. Case number 128612, Mark Crawford versus Spirit Aerosystems, Inc., and AIU Insurance Company. And parties, you can submit your appearances when you go to the podium. Do you want to keep this? Yeah, fine. I have lots of copies.
May it please the court, Jeff Cooper, attorney representing Mark Crawford, the claimant for the injured worker in this workers' compensation case. The claimant appeals from a
Oh,
board decision.
Mr. Cooper, can I
Yes.
interrupt you for a second?
Sure.
How much rebuttal time would you like?
2 minutes, please.
All right, thank you. 2 minutes will be granted. We're gonna, if you can just wait for a second, we're gonna get that clock going so you could start with 13. Thank you.
Thank you. Claimant appeals the board's finding that the claimant failed to meet its burden of proof that his repetitive trauma injury, December 1st, 2020 through January 22nd, 2021, was the prevailing factor in causing his cervical spine and shoulder injuries. Claimant requests that the court issue an order finding the board's denial of those benefits was not based on substantial competent evidence, and I'll go into more detail on that in a moment. We believe the credible evidence supports the finding that his work injury was the prevailing factor causing his injuries, his need for treatment, and resulting disability or impairment. Factually, the claimant began working for the respondent in February of 2014 as a sheet metal fabricator, which everybody agrees was a medium to very heavy job. Job requirements require him to lift 25-pound braces, 2 at a time. So he's lifting 50 pounds, and he has to flip those, install those. And during the course of installing and flipping those boards, starting in December, he developed severe neck pain, especially on the right side. I think it's important to note that the claimant worked this job for 6 years before the injury. He provided written documentation of no physical limitations when he was hired. In fact, he took and performed a pre-employment physical at the request of the employer for the heavy job, and passed that and worked that heavy job for 6 years until his problem started. Now, he did have some minor incidents of neck pain in the past. Record talks about an incident in 1999 while at Worlds of Fun. Didn't have any lasting problems from that. He fell on the ice in 2008. He was cleared after falling on the ice by Dr. Barrett. No restrictions, no impairment from that event. Next known record of any neck pain is 2016, after he goes to work at Boeing. And that was through Dr. Reichenberger, his primary care physician. Dr. Reichenberger, excuse me. So Dr. Pratt, who did a court-ordered IME, and I'll explain that in a moment, did indicate that Dr. Reichenberger in 2016 indicated the claimant at that time had left-sided neck pain and tingling in his left arm at that time. I'll submit that both the ALJ and the board erroneously said that in 2016 he had right-sided neck pain. There is no evidence of that, and we submit that that's an error. His complaints following the work-related injury were to the right side primarily at that time. There's no records of any right arm complaints from Dr. Reichenberger until January 15 of 2021. I submit that's important because Dr. Pratt ignored those records. There's no complaints of any right-sided neck pain, any right-sided arm tingling pain. The notes from Dr. Reichenberger notes a 4-week history of pain in the right side of his neck, shooting into his right arm, which he attributed to his work activities. There's no notes that are in the record of any complaints from 2016 until this injury of 2020. He was, again, working a heavy job, full-time, without any problems. Spirit denied the claim. We sent him to see Dr. Marati. Dr. Marati said the work injury was the prevailing factor. Insurance company sent him to Dr. Feverly. Dr. Feverly said work injury was not the prevailing factor, that smoking and his age were the problems. Based on that, the administrative law judge sent the claimant to see Dr. Terrence Pratt, a physiatrist in Kansas City, for a court-ordered IME. Dr. Pratt states he couldn't relate his cervical problems to work activities, and he said he had prior symptomatic involvement. I think it's important to note right here that if you read Dr. Pratt's report, there's no evidence that he had any indication that this gentleman was working a heavy job for 6 years before this event at work occurred. I think that shoots a hole in his opinion, and I think the board and the judge erroneously relied on his report when he didn't have the factual basis to make that determination.
And counsel, when you say event at work, am I correct that there wasn't like one precipitating event? There wasn't a fall or some incident that happened one day. It was a progressive, kind of repetitive.
Yeah, it's what we
injury
call in
over-
the practice a repetitive trauma injury, where
Okay.
you're doing your normal work activities and you start having pain. And that's what he testified about, and that's what all the records consist of. And I don't think the respondent's denying that he had a work-related event. They're just denying that it didn't cause the problems that he ultimately had surgery
They
to
characterized
correct.
it more as a flare-up of a
Yeah,
pre-existing.
yeah, they say it's
Yep.
just an aggravation of a pre-existing condition, which in Kansas is not a compensable event anymore. I again submit that for the right shoulder, there's no significant evidence of any pre-existing condition. Like I mentioned, Dr. Pratt never mentioned, was not aware that this gentleman was working a heavy job for 6 years without any significant problems. Never was taken off work until this event happened.
So the smoke and old age reasoning really doesn't fit then, does it, or does it?
Well, that's our position, that the board relied on his testimony when it wasn't based on all the evidence that should have been taken into consideration. If you take his testimony into consideration, which is not refuted by anybody, he worked there 6 years and nobody denies this was a heavy job, physical job that he did without any problems until started having problems in December. Dr. Pratt never even considered or mentioned any prior complaints being left, and pretty minor complaints. Here his problems are on the right side, doesn't even address that. But based on Dr. Pratt's opinion, the court denied any treatment, and the claimant sought treatment on its own with Dr. Dickerson, who most of you probably are familiar with, a neurosurgeon with a very high reputation here in Wichita. Dr. Dickerson performed surgery. He saw what condition was of this gentleman's neck, and he said that based on his findings from the surgery, that the work event was the prevailing factor resulting in the need for his hernia surgery and his resulting impairment and disability.
Now, counsel, let me step back a little bit. It's my understanding that yes, Dr. Dickerson, when performed the surgery, his findings found the surgery was necessary, but it's my understanding that the only connection between the condition and the employment and the only basis for Dr. Dickerson to make that connection was your client's subjective history to Dickerson, telling him they were connected. Is that true? Is there something else that he based that on?
I think that is essentially true. I mean, that's where Dr. Dixon got the information. But I asked Dr. Dixon, you can read his deposition, when he did the surgery, he saw what he thought were acute findings that were causally attributable to his work injury. He didn't say he did surgery on this guy because he had old age problems. He said he had herniated disc and that those discs were caused by the work events.
But he also didn't review any past medical records, correct?
Yeah, and that was a big point that was made. What past medical records are relevant? That he had some minor pain before? Dr. Dickerson very clearly said, there's no way this guy could work for 6 years with the condition of his neck that I saw him on when I did the surgery. So you're correct. He did not have the prior records review. I didn't hire him as an expert. I took his deposition because my client had surgery by him, and I contend that based on the surgery, he is in the best position to tell the court what the cause of the problem is. It's our position that the court's reliance on Dr. Pratt is erroneous because he didn't have all the information he needed to make that determination. I think it's also not common sense. This gentleman couldn't work for 6 years and do the kind of job he did.
Can we go back to Dr. Dickerson? It's
Sure,
my
absolutely.
understanding that the Spirits Council, they cited some other testimony in their brief from Dr. Dickerson where he supposedly admitted that he saw degenerative changes and some recess narrowing in the MRI that would take years to develop, and agreed that those conditions could be asymptomatic. Do you have any disagreement with?
Oh, I think,
I mean,
you
did
know,
he-
certainly I can't disagree with Dr. Dickerson. He's very well trained and an expert. I think all of us, when we get 65 or thereabouts, we probably have some degenerative problems. I can't dispute that this guy, he worked hard his whole life, he has degenerative problems. But Dr. Dixon, I believe, very clearly said the reason he did the surgery and the reason he had to have the surgery was because of the work injury and the herniated discs that he operated on. We believe that if you look at all the evidence in the record, the reliance on Dr. Pratt is erroneous. It's not based on competent medical and competent evidence and should be not utilized by this court.
What's the problem with relying on Dr. Pratt's opinion? I mean, that the court appointed him, and it's my understanding that he did look at the past medical records to kind of come up with his analysis. What's your issue with the basis for his opinions?
The basis for his opinion is he didn't consider all the appropriate information to arrive at an opinion. He assumed he had old age-related problems, but he didn't look at his work history, didn't look at his lack of symptoms, working a heavy physical job for 6 years. I mean, he had some very minor problems, but look at Rickenbacker's records. Rickenbacker's talking about left-sided neck problems that are minor. You know, he sees him one time, basically, for each little episode. There's no ongoing treatment. There's no, complaints of ongoing pain and problems. And that's consistent with what Dr. Dickerson and consistent with what my client says, that he got along very well up until December when he started having problems while flipping these trusses and braces and lifting the heavy weights. And he described the pain as different, much more severe than what he had ever had in the past. And that would be, again, I believe, consistent with Dr. Dickerson's testimony in the case. Looks like I'm about out of time. I think I've covered the main points. In conclusion, we just believe that the board's decision doesn't meet with the credible medical evidence and the factual evidence in this case. I would request a careful review of that. Thank you for your time today.
Thank you. You'll have your 3 minutes for rebuttal.
Thank you.
Hey, please the court, Vince Burnett on behalf of Spirit Air Systems and its insurance carrier AIU. Also present is Pam Parker, who was on the briefing for all of the briefs that we filed. Clearly, it's a workers' compensation case. We have exhaustively briefed this case, not only to the judge with a submission brief outlining the evidence, also to the appeals board, and then obviously to this court. I want to start with the standard of review, and I'm sure you already know about it, but obviously I think it's important in this case because of what counsel for the claimant is asking the court to do is reweigh the evidence, reweigh the facts, reweigh the credibility determinations by the administrative law judge and the board, and essentially asking the court to do a de novo review of the facts in this case, which certainly the standard of review under the Kansas Judicial Act is not allowed. I do want to point out, and maybe I should explain before I point that out. In workers' compensation, what happens a lot is claimant says he's injured, and in this case, he went to his primary care physician, Dr. Reichenberger. He didn't even go to Spirit to report it initially. He went to his primary care doctor and said, hey, I woke up with a stiff neck. And that was his initial report, and that's important because I think that goes to actually what he related his symptoms to initially in his neck was, I slept wrong or I woke up with a stiff neck, never related it to his employment until subsequently. And then once he talked to his PCP some more, then he decided it was a work comp claim and he made a claim against Spirit. We generally, in that case, will send him out for a medical evaluation, whether it's with a local doctor or to an IME physician. We also, particularly under prevailing factor, which obviously wasn't a thing until 2011, when the law was changed. Before 2011, any aggravations or accelerations of pre-existing condition were compensable. You just had to show 1% aggravation, it was compensable. But 2011 changed that entirely and established this rule of prevailing factor, which I would submit to the court. And as Your Honor pointed out, you can't rely on an expert that doesn't know the past medical history at all. And that's what I would submit Dr. Dickerson occurred in this case.
Well, and to that point, it's my understanding that one of the biggest problems that the claimant has with Dr. Pratt's opinion is that Dr. Pratt didn't view a pre-December 2020 MRI, and so he couldn't opine on whether the claimant suffered a change in the physical structure of his body or had new physical findings. Is that correct? That he just reviewed other doctors' interpretation of the MRI, but didn't look at the MRI himself?
I don't think Dr. Pratt's, Dr. Pratt's deposition was not taken. His report comes into evidence because it's a neutral court-ordered IME, so no further foundation. So I don't know if he actually reviewed the films or just read the radiologist report, which is an interesting point because Dickerson, and I've taken Dickerson's deposition several times. He's always in favor of everything being work-related, not uncommon in this case that he made that conclusion. But the radiologist's interpretation of the MRI was all degenerative. And then he, what I call overread, which is essentially, I disagree with what the radiologist is saying, even though the radiologists look at hundreds of MRIs probably on a weekly basis. But a lot of surgeons will overread the MRI findings of the radiologist and say, no, I think there's more than just degenerative changes. But Dr. Pratt did have the MRI, either the radiologist report or the films. I'm not certain because we didn't take his deposition. But that's a red herring. I mean, I don't think it goes to really the weight of the evidence. And counsel's made this argument here today that Pratt didn't know what his job responsibilities were. Well, if you look at, and this is part of the regular hearing because it's attached to the regular hearing, I'd have to look up the record of appeal to see what it is. But Pratt's report's in evidence. And, you know, page 1, claimant says he reports that he was lifting 65 to 70 pounds. Frames when he noted the aching in his shoulder arm on the right. Page It's reported a second time on page 2 of Pratt's report, under vocational history. Counsel says, well, Pratt didn't ask him anything about what his job duties are. Well, it's in there twice. On page 2, he says he performed activities at Spirit since 2014. At the time of his current complaints, he was working on parts or frames, lifting 75 pounds, blah, blah, blah. That's, again, a red herring just to try and place shade on Dr. Pratt's opinions. But he's the only neutral physician. I'm sure the court knows that, I started off my little conversation. Claimant says, I got injured at work. We send him to a doctor who says, no, this is not work-related. Then they hire their own expert, in this case, Dr. Marati. And Marati says it's all work-related. And then the court, because it's presented with competing medical opinions as to causation, sends them out to a neutral IME doctor, which in this case was Dr. Pratt, who did not relate causation for his neck condition to his work activities. But Pratt did obtain from the claimant, and he also had the benefit of reviewing these other IME reports from Marati and from Dr. Feverly, that gives a history of what the claimant has told these different physicians. And he can look at all those reports and make his own conclusions based on the history that he obtains from the claimant as well. And obviously, Pratt's basing his opinions not just on records review, it's also on physical exam, review of testing, history from the claimant and all that. And based on the presentation, obviously he didn't feel it was work-related. Dickerson, on contrast.
Well, and let me stop you right there too, because that's
Okay.
another argument that they're making is Dr. Pratt didn't say it's not work-related. He said, and it's my understanding they're saying this is a problem too because he's using the wrong standard. Pratt says, I can't state to a reasonable degree of medical certainty that the multi-level discogenic changes identified on the cervical imaging relate to his vocationally related activities in December 2020 until 21. And it's my understanding they're saying that's the wrong standard. He doesn't come out and say, no, it's not work-related. He's saying, I can't tell you within a reasonable degree of medical certainty that it is. Are we splitting hairs or is that important?
It's not important, it is splitting hairs. If you look at page 5 of Dr. Pratt's report under prevailing factor, he specifically says for the cervical thoracic involvement, pre-existing symptoms involvement documented in the record. So he's already pointing that this is an aggravation, acceleration, not that work is the prevailing factor. He goes on to say the rest of it, but that's the way of saying, well, if I'm convinced it is work-related, then I would state within a reasonable degree of medical probability or certainty it is related. He's just reversing that around. It could have been better articulated, but I think it's the same. Anything else on that? I just got a couple
No,
of...
I just wanted your position on that argument.
All right, so the thing about Dickerson, as I pointed out in our briefs, is we show up, counsel takes his deposition. There's good reason to take his deposition. He was a surgeon, but he'd already obtained an opinion from Dickerson that said he thought it was work-related. That's really the reason for Dickerson's deposition. But Dickerson didn't review any of these records, and these are significant. As we pointed out in our brief, it's not just, it's a minor problem.
Do you mind if I interrupt you? Would he have to, I mean, I know he hasn't reviewed the record, yes, valid. But he's the only one who cut into Mr. Crawford. I mean, he saw what was actually happening to the body. So shouldn't we give that great weight versus, he hasn't reviewed his other medical records? Surely if he's going to do surgery, he's going to be reviewing the person's patient history, right?
I get your point, but prevailing factor is a specific standard under work comp.
Right.
And you can't just rely on the subjective complaints of the claimant. I mean, claimants have a tendency to exaggerate their symptoms to begin with, and second of all, attribute everything to work versus, oh, I had this prior injury and I'm fine now, even though they had permanent restrictions, which I'll get to. But prevailing factor is a specific statutory provision in the statute that they must overcome, and you can't do it with a Dickerson who doesn't know anything about his past medical
And so even if he opened up and said, I see all this injury here, you may not have the prevailing factor there.
Yeah, I mean, I once asked a doctor, because I've been doing this too long, 40-some years, but, okay, in an MRI, can you tell me if that's, when that happened? When did that
Exactly,
MRI
that's
happen?
that was my point.
And the doctor says, well, look at that scratch on that table. Can you tell me when that occurred? No. And he had significant degenerative disc disease. It wasn't just a little bit, it was a lot. And in order to, and disc herniate, you could sneeze and herniate a disc. It doesn't have to be work-related. But he had signs and symptoms of radiculopathy, which is from a herniated disc. In his previous treatment, even his family doctor treated him for epidurals in a cervical spine and did an MRI. So this story that all the other prior injuries were minor, that's flawed too. He even had a previous settlement against Arby's that's in the record when he slipped and fell on the ice. So that's where I was headed, but
What about the argument that was made today that Dickerson, once he cut into him and saw the condition of the herniation of the disc, said he wouldn't be able to work with this significant of an injury, so obviously this was something new and different than what he had before?
well, I would submit to you so the timeline on this is they get a report saying it's work-related. We get a report that's saying that it's not work-related, or vice versa originally. And then it goes to a neutral, which the Pratt evaluation was in
July of '21.
July of '21. When's the first time he sees Weimer? Let me look. Because he saw a different doctor at the same group, had a different history. I'll have to dig it out because I'm not. What I was going to say is there's a lot of time in between he last worked and when Weimer saw him. I guess I don't have the portion of my medical summary that tells me when he saw Weimer. There was some time between the visits and, who knows when those discs herniated, if they truly were herniated. Again, the radiologist did not describe them as herniated discs. I think it's convenient for a surgeon that goes into surgery and said, oh, there's herniation here, justifying the surgery, because they probably need to get it covered by his health insurance. You can't just do the type of surgery that he performed on subjective complaints. You really got to have a diagnostic findings. But my point is, these priors were significant. They weren't just minor, and I think a cumulative effect a little bit. We detail all of the priors over the years, including from his primary care physician, and then subsequently on page 3 of our Court of Appeals brief, he had previous neck problems in 2018, previous work comp claim in 2008, that's the one with Arby's where he received a settlement. Another funny point I find in this is, if you read Roddy's deposition, I went after him on this issue, is Roddy provided an evaluation in 2008 for the Arby's claim. He's the same expert they're now using on this claim. Roddy placed permanent restrictions on him in 2008. Did he honor those permanent restrictions? No. And on top of that, signed impairment for a upper back, neck, thoracic. Back in the day, it used to be cervical, thoracic. Now, under the 6th edition of the AMA guides, they've separated. But under the 4th, it used to be cervical, thoracic. But I questioned Roddy about, hey, you had a prior claim in 2008. You assigned permanent restrictions. Claimant says, well, he was fine. Didn't have any problems. Well, why was he assigned permanent restrictions? And in my book, permanent means permanent. He had bulging discs in 1999. He had the incident with the previous neck injury at Worlds of Fun. He had the previous episode while teaching his children to swim. I mean, he's got a chronic history of neck issues, is the truth and facts of the case. So I know my time's about up. One final irony in my mind is they want to use Dickerson's opinions to say causation is met, but when it came down to saying, they also want to argue he's incapable of working. Well, Dickerson actually did surgery on him and released him with no restrictions. So it's, I think, inconsistent to say one thing and then say the other. So, thank you. Any other questions? I know I went fast, and I apologize, but nature of work comp.
Thank you.
Not
We
fast.
appreciate it. We appreciate your 47 or 42 years.
88.
All right.
A little less than Jeff. So graduated from law school in 88.
Oh,
He's just
wonderful.
a kid, you know?
Mr. Cooper, you have your rebuttal time. We're going to move the clock to 3 minutes.
Thank you. I don't have a whole lot to say in rebuttal. I think the best evidence is the fact that this gentleman, even though he had some minor stuff before, he worked 6 years doing a heavy job without any problems until this injury. And then you get bids hiring doctors that nobody's ever heard. Everything's pre-existing condition.
Can
We
you,
sent him to
can you
Dr.
do me
Roddy
a
and
favor and speak, I'm sorry, to the standard of review at this point, rather than so
Right,
heavy into some of the
exactly,
facts?
yeah.
Give me the standard
And
review.
There's both sides of that, exactly. The standard review is what the evidence shows, and I think based on all the evidence, we believe the evidence shows that he did meet his burden of proof in proving that the work event was the prevailing factor in resulting in his injury, need for treatment, and impairment or disability. So we would request a finding in that regard. And unless you have any questions, that's all I have to
Well,
say.
what's your response, I mean, while you're up there, about the permanent restrictions that Maradi imposed? It's my understanding they're relying on that. They mentioned it today as indication that
Well, I
there
think
was
Dr.
continuing
Brody
problems.
testified about restrictions or his recommendations considering the condition that he saw him at that time. But clearly, he worked a lot of different jobs after that without any significant problems. I don't think that's really relevant here. He applied for and was accepted and passed a test to work a very, very heavy job at Spirit and did that for 6 years until he's flipping them and has the pain and problems. And that's what, I think council made some suggestion that he just told him he slept wrong. It's pretty clear from Dr. Reichenberger's records that he's referring his problems to his work activities. So I think that's not quite correct. I'm sure you'll read the records, but look at Reichenberger's. This is his family doctor. He's not going there once a month or once every 6 months saying he's got neck pain or problems. There's no evidence after 2018 when he got a little bit of treatment up until 2020, 2021 was when next time, 3 years, when he saw Dr. Reichenberger. No evidence of any kind of neck problems that required any kind of treatment during that period of time. So I think that based on the totality of the evidence and the fact that Dr. Pratt didn't have the proper elements to review to arrive at the opinion that the board followed, warrants this being changed. Thank you.
Thank you, Mr. Cooper. All right, we will take this matter under advisement. And so we've ended the afternoon docket. Thank you for your well-argued presentation today. This time we are adjourned.
All rise.
You just come down for this yet?
Oh, I had a regular hearing this morning, so worked out pretty good to do that.
Yeah, yeah. Well, we know you didn't write it, so.
Well, yeah, Jordan writes.